It finally happened! The bromance we thought would last forever is over. President Trump is breaking up with the Svengali figure using billions of dollars of dark money to remake every branch of American government. What once was true love has descended into an ugly slap fight with public recrimination and big feelings and mean tweets. That's right, Donald Trump is breaking up with Leonard Leo and the Federalist Society, the highly influential conservative legal group that spent the past 4 decades working to remake the judiciary. What, you were thinking of some other massively ugly public breakup? Trump is bigly mad because even judges he appointed to the bench are ruling against him when he flagrantly violates the law, which is constantly. This particular temper tantrum was about the tariff case where a 3-judge panel on the U.S. Court of International Trade ruled that Trump's emergency tariffs were totally illegal. The nerve! But Trump is losing in court a lot, and often with conservative judges. So he's vowed to ditch the FedSoc, and not just them. He's also going to war with the American Bar Association, which traditionally played a central role in vetting federal judges. Attorney General Pam Bondi says judicial nominees are going to give the ABA the back of the hand going forward, all of which is very weird. But before we get too deep in the weeds, let's talk about how this usually goes down. Traditionally, home state senators came up with a list of potential district court nominees for the president to choose from. They were presumed to know all the eminent practitioners in their own backyards and be able to select someone whose temperament suited the state where they would be sitting. Usually, the president would nominate someone from that list, and the American Bar Association would then vet the candidate using a grade of well-qualified, qualified, or not qualified. And it's important to understand that this evaluation was not just based on vibes. The ABA Standing Committee is made up of 15 prominent lawyers from every federal circuit. It has an official rubric to provide impartial peer evaluations of the professional qualifications of judicial nominees. It aims to ensure that nominees to a lifetime appointment on the federal bench have the highest integrity and professional competence, as well as a judicial temperament characterized by compassion, decisiveness, open-mindedness, courtesy, patience, freedom from bias, and commitment to equal justice under the law. At a minimum, nominees should have at least 12 years' experience in the practice of law, with substantial courtroom and trial experience as a lawyer or trial judge in state court. The process begins with an extensive questionnaire to the nominee, who signs a waiver to allow the ABA to access their disciplinary records. The ABA evaluator, usually the member of the standing committee from the nominee's home circuit, reads everything the nominee has ever written and talks to at least 40 people who know them. And then the evaluator interviews the nominee, allowing them to rebut or comment on anything those 40 people said. The evaluator writes up a report for the full committee to vote on. If the nominee is rated unqualified, the ABA will send a letter to the Senate Judiciary Committee explaining why. In the past, judicial nominations were at least supposed to be apolitical. Nominees of either party were routinely approved with substantial majorities. In 2003, Chief Justice John Roberts was confirmed to the Court of Appeals in D.C. unanimously on a voice vote. And 2 years later, he got 78 votes when President Bush nominated him to serve as a Supreme Court justice. The ABA rated him well-qualified both times. But that process has been breaking down for decades. Back in 2003, Democrats began ramping up use of the filibuster to block George W. Bush's judicial nominees. Senate rules at the time allowed the minority party to block judicial nominees unless they could overcome a 60-vote filibuster threshold. The implied threat of the filibuster forced both parties to nominate relatively moderate candidates like Roberts. But the filibuster was rarely used and was effectively an emergency measure. So Republicans were pissed that Democrats were filibustering 2 nominees at once. Now, Democrats would say that was because Republicans started nominating radicals bent on overturning Roe v. Wade rather than ostensible centrists like John Roberts. But Republicans started talking about getting rid of the filibuster for judicial nominations, and right-wing groups like the Judicial Crisis Network sprung up and started screaming about the so-called crisis of unfilled judgeships because Democrats were blocking Bush's nominations. But when Barack Obama got elected in 2008 and Democrats took back the Senate, they changed their tune. Minority Leader Mitch McConnell vowed to make Obama a one-term president and use the filibuster liberally to block his judicial and executive branch nominees. During 2009, the first year of Obama's presidency, the number of judicial vacancies almost doubled from 53 to 100. More than 1 in 10 seats on the federal bench was empty, a problem which continued throughout Obama's first term. After he was reelected in 2013, Democratic Senate Majority Leader Harry Reid invoked what was known as the nuclear option, getting rid of the filibuster for district and circuit court candidates. but not for Supreme Court nominations. At the time, he noted that more than half of all nominees filibustered had come under President Obama. 3 years later, when Justice Antonin Scalia died, Obama nominated Merrick Garland, the Chief Judge of the D.C. Circuit, to replace him. But by then, Mitch McConnell was the majority leader, and he wouldn't even give Garland a hearing. He invented a new rule that said a president wasn't allowed to nominate Supreme Court justices in his last year in office. Then in 2017, with Trump in office, McConnell blew up the last remnant of the judicial filibuster to confirm Neil Gorsuch. And the filibuster isn't the only moderating tradition the Senate has just discarded. In the past, a judicial nominee would not move forward unless both senators from his or her home state showed their approval by turning in their blue slip. It's literally a blue permission slip. So if a state had a Republican senator and a Democratic senator, they had to both agree. And if there was a Democrat in the White House, he could only get a judicial nominee through with the buy-in of both senators from, say, Alabama. In 2015, Iowa Senator Chuck Grassley, chair of the Judiciary Committee, wrote an op-ed in the Des Moines Register saying, over the years, both parties have upheld a blue slip process, including Senator Patrick Leahy, my immediate predecessor, who steadfastly honored the tradition even as some in his own party called for its demise. I appreciate the value of the blue slip process and also intend to honor it. But in 2017, after Trump got elected, he put out a statement entitled Grassley to Maintain Historical Blue Slip Courtesy. In it, he announced that he was going to hold a hearing for 2 circuit court nominees, each of whom has one home state senator who has not returned a blue slip containing a positive endorsement, which is a little like saying you're celebrating your new life as a vegetarian by scarfing down a bacon double cheeseburger. Over the past 9 years, things have not gotten better. Blue slips are effectively dead, the judicial filibuster is gone, and everyone just accepts that judicial nominations are now a wholly political exercise. And it's fair to say that no organization in America bears more responsibility for politicizing the judiciary than the Federalist Society. Founded in 1982 at Harvard Law School, Yale Law School, and the University of Chicago Law School to protect liberalism, the FedSoc spent 4 decades trying to remake the federal and state judiciaries to align them with conservative, free market values that emphasize individual liberty and oppose collective responsibility and government solutions for social and economic problems. With chapters at every major American law school, the Federalist Society forms a spectacularly effective pipeline, shaping the ideologies of conservative law students, providing them opportunities to network with like-minded professionals, and funneling them through prestigious clerkships that lead to judicial nominations. And whether you think that's great or terrible, you have to give credit to a man named Leonard Leo for creating this absolute juggernaut. Leo founded the FedSoc chapter at Cornell Law School in 1989 and went to work for the organization in 1991. He shepherded conservative judicial nominees through the Senate confirmation process, including every Republican Supreme Court nominee since Justice Clarence Thomas in 1991. He presides over a network of conservative organizations that shaped conservative policy and placed judges in every state and federal court, and he's done it by hoovering up billions of dollars in dark money from very wealthy people who hate paying taxes and hate environmental regulations and hate antitrust regulations, and they hate consumer protections, and they hate unions, and they're not so big on civil rights either. Leo's also got a fair number of donors whose main goal in this life is to make abortion illegal and bring back Christian prayer in schools. With his hundreds of millions of dollars a year, Leo has woven a web of influence over conservative policy and nominations. He's also made life pretty cushy for people who delivered on his goals. In 2012, amid reports that Justice Thomas was considering leaving the Supreme Court so he could go make more money in private practice, Leo funneled tens of thousands of dollars to the justice's wife, Ginny Thomas, through the Judicial Education Project, one of his many nonprofits. He told Republican insider Kellyanne Conway to send a bill for another $25,000 and give the money to Ginny while keeping her name off the paperwork. Conway duly sent a bill for Constitution polling and opinion consulting and ultimately invoiced between $80,000 and $100,000. Leo's various outlets also paid Ginny's Liberty Consulting Group to support conservative causes, and Harlan Crow, the Texas billionaire who paid tuition for Thomas's adopted son, bought Clarence's mother's house and let her keep living there, and took the Thomases on various luxury trips, is a major donor to Leo's causes. Here's a portrait painted for Crow depicting Leo, Thomas, and Crow at Crow's private resort in the Adirondacks. Also pictured is Clarence and Ginny's personal lawyer, Mark Paoletta. He's currently the general counsel at the Office of Management and Budget, which is smack in the middle of a whole lot of fights headed for the Supreme Court over the Trump administration's refusal to spend congressionally allocated funds. Do you think Justice Thomas will recuse himself on those cases? In Trump's first administration, 43 of 51 of his circuit court nominees were Federalist Society alums. 5 sitting Supreme Court justices were members, and a 6th, Chief Justice Roberts, certainly hasn't kept his distance. These are people who have given Trump almost everything he wants, including immunity from criminal prosecution. I don't know why he's mad at the FedSoc, and frankly, he's got nothing to whine about from the ABA either, but that's not going to stop him. As you may have heard, Donald Trump gets sued a lot. One of those suits is called Global Health Council v. Trump, and it concerns the cancellation of USAID grants. Remember, the United States Agency for International Development is one of the agencies Elon and the Doge Bros burned down on the theory that humanitarian aid like malaria shots and emergency rations for starving babies is a scam. On February 11th, a consortium of USAID grantees sued to block the grant cuts, and one of the plaintiffs was the American Bar Association, which receives grants through USAID and other federal agencies to promote democracies abroad. The ABA alleges in the complaint that cutting it off has decimated ABA's programs, including its efforts to protect religious freedom in Asia, fight human trafficking in the Democratic Republic of Congo and Colombia, prepare Ukraine to recover from Russia's invasion, advance democracy in Myanmar, and combat money laundering and terrorism in South America. Now, suing the government is core constitutionally protected speech. It says it right there in the First Amendment. Congress shall make no law abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for redress of grievances. That last one is the suing part. And yet, on April 9th, Deputy Attorney General Todd Blanche sent out an all-staff memo to the Department of Justice, barring any DOJ employees from interacting with the ABA, and he explicitly connected it to the ABA's lawsuit. He said the ABA is free to litigate in support of activist causes, including by inserting itself into pending litigation as an amicus curiae. But public service is a public trust. The Department of Justice must, consistent with the Constitution, be careful stewards of the public fisc, represent all Americans regardless of ideology or political preferences, and defend the policies chosen by America's democratically elected leadership as reflected in congressionally enacted statutes and presidential policy choices. Blanche said that it was inappropriate for Trump administration employees to support an organization that was undermining its policies by exercising its First Amendment right to sue the government. He barred policy-level employees from interacting with the ABA at all, including renewing their memberships, and said that non-policy employees could do it on their own time, but not using official Justice Department titles. He banned them from using so much as a Post-it note to record the date of an ABA conference or RSVPing using their work emails. And the very next day, the Justice Department canceled $3.2 million of grants to the ABA's Commission on Domestic and Sexual Violence for domestic violence prevention. Those are programs that do things like train lawyers to help survivors of domestic violence get restraining orders. The DOJ assured other grant recipients under this program that their funding would not be cut. And the letter to the ABA purported to cancel 2 grants that had already ended, which strongly suggests that the review process involved Control F plus ABA rather than some kind of program-specific evaluation. On April 23rd, the ABA sued the Justice Department for retaliating against it for exercising its First Amendment rights. And on May 14th, they got a preliminary injunction restoring their domestic violence funds, which, yeah, no kidding. As Judge Christopher Cooper said in his order, the government does not meaningfully contest the merits of the ABA's First Amendment retaliation claim. But that was not the end of the matter. And then, on May 29th, Attorney General Bondi wrote a letter to ABA President William Bay saying that the organization would no longer receive special treatment and access to judicial nominees. She said the ABA no longer functions as a fair arbiter of nominees' qualifications, and its ratings invariably and demonstrably favor nominees put forth by Democratic administrations. That is nonsense. The ABA bent over backwards to be fair to Trump's nominees, and there is no reason that Trump would lack for qualified candidates thanks to Leonard Leo and the FedSoc. The country is full of conservative lawyers with perfectly acceptable resumes who can easily pass muster with the ABA. Trump just nominated a bunch of unqualified goobers instead, like this guy, Brett Talley. Now, the ABA did not rate Talley as unqualified because he writes silly horror novels with titles like Haunted Alabama Black Belt, which is honestly kind of great. What's not great, though, is that Talley was just 3 years out of law school and had never tried a case or even filed a motion, or, as the ABA put it in its very polite letter to the Judiciary Committee, Mr. Talley does not presently have the requisite trial experience or its equivalent. The ABA did not point out, although I did, that Talley had left out one or two important details on the section of the questionnaire that asked about potential conflicts of interest. I guess it slipped his mind that his wife Ann Donaldson was a chief deputy for Trump's White House counsel Don McGahn. Oopsie, Talley did not get confirmed. But speaking of spousal benefits, you know who did get confirmed to a seat in the Middle District of Florida? This lady, Catherine Mizell. She's the wife of Chad Mizell, who was at the time general counsel of the Department of Homeland Security. He's now chief of staff at the Justice Department. And in 2020, Catherine Mizell was 33 years old, just 8 years out of law school, and had never tried a case, civil or criminal, as lead or co-counsel. The ABA rated her not qualified, but that's not because the ABA is biased. That's because Talley and Mizell were grossly unqualified Nepo babies. And the Trump administration wasn't complaining about the ABA in 2020 when it blasted out this op-ed from the conservative National Review, bragging that President Trump's judicial appointments have earned the ABA's well-qualified rating at nearly the highest rate in 5 decades, the highest rate of any president since at least Gerald Ford. So Pam Bondi can call the ABA an activist organization and promise that nominees will not respond to questionnaires prepared by the ABA and will not sit for interviews with the ABA. And no one can make those nominees submit to the evaluation process. But this whining about bias is baloney. So if it's not going to be the ABA or home state senators, who is going to vet judicial candidates? Well, it's not going to be the Federalist Society. So remember that tweet from the top of the video where Trump was yelling about Leonard Leo? Okay, I know it's not a tweet and Twitter is no more, but you cannot make me call that post a truth. Not now, not ever. So first, Trump started off howling about the decision from the Court of International Trade and saying, where do these initial 3 judges come from? How is it possible for them to have potentially done such damage to the United States of America? Is it purely a hatred of Trump? What other reason could it be? Well, we have an answer for that one, and it is that Judge Jane Rastani was nominated by Ronald Reagan, and Judge Gary Katzman was nominated by Obama, and Judge Timothy Reif was nominated by one Donald J. Trump. As to why the panel ruled against him, well, he could read the opinion or he could watch that LegalEagle video. But TLDR, they ruled against him because the Constitution says that the power to tax and lay tariffs belongs to Congress, not the president. But I think we interrupted the dear leader mid-rant. I was new to Washington, and it was suggested that I use the Federalist Society as a recommending source on judges. I did so openly and freely, but then realized that they were under the thumb of a real sleazebag named Leonard Leo, a bad person who in his own way probably hates America and obviously has his own separate ambitions. He openly brags about how he controls judges and even justices of the United States Supreme Court. I hope that is not so, and I do not believe that it is. In any event, Leo left the Federalist Society to do his own thing. I am so disappointed in the Federalist Society because of the bad advice they gave me on numerous judicial nominations. This is something that cannot be forgotten. With all of that being said, I am very proud of many of our picks, but very disappointed in others. They always must do what is right for the country. Let's see if we can translate that one. Trump put a lot of judges on the bench on the assumption that they'd rule in his favor every time and owed it to him to do so. And they haven't. Like Judge Fernando Rodriguez Jr. in the Southern District of Texas, who said that Trump couldn't just send people to a gulag in El Salvador without giving them an opportunity to say, hey, I'm not a criminal. Or Judge Stephanie Gallagher in Maryland, who is this close to finding the Department of Homeland Security in contempt because it agreed not to deport a group of immigrants brought here as children while their asylum claims were pending, and then DHS sent at least one member of that group to CCOT in El Salvador anyway. Or Judge Trevor McFadden in D.C., who said Trump could not exclude the AP from press briefings just because it refuses to say Gulf of America. Well, don't worry about that last one. Judges Gregory Katsas and Naomi Rao, 2 Trump appointees on the D.C. Circuit, reversed Judge McFadden's order. But no one makes MAGA world madder than Chief Justice Amy Coney Barrett, who has shown a marked independent streak. In March, she and the Chief Justice sided with the court's liberals in the USAID funding case that the ABA signed on to, saying that the government couldn't mass terminate foreign aid grants without a reason. She sided with the court's liberals in March in a decision about the EPA's ability to stop factories in California from dumping raw sewage into the Pacific Ocean. And she's been in the majority that stopped Trump from summarily deporting immigrants without due process. Plus, she really seems to be personally appalled by the president's behavior. Naturally, Trump's supporters have started snarking about Barrett as a DEI hire, which is exactly what they say about Justice Ketanji Brown Jackson, a Harvard Law graduate who served on the D.C. Circuit, i.e., she has the same resume as Roberts, Thomas, and Kavanaugh, but no one ever calls them DEI hires. Trump is mad at Leonard Leo because he only gets 90% of what he wants from the courts, and so the FedSoc is out. Incidentally, do not cry for Leonard Leo. He got $1.6 billion in capital from a 91-year-old industrialist, and he's now using it to make conservatism cool again. So if you see Amazon recommending high-budget Bible flicks to you, now you know why. Try TikTok, Leo. The kids love that stuff. Anyway, without the FedSoc feeding the White House a steady stream of qualified nominees, Trump is going to have a much harder time filling any judicial vacancies. Luckily, he has a dream team of lawyers just waiting in the wings. Oh, you think I'm kidding? Trump already nominated his personal lawyer, Emile Beauvais, to the Third Circuit. You probably remember Beauvais as the guy who blew up the prosecution of New York Mayor Eric Adams and caused half the prosecutors in the Southern District of New York to quit in disgust. Probably just a matter of time before we get Supreme Court Justice Alina Habba. Thanks, Donald. There's a lot of crazy stuff going on out there today, which is why online privacy is so important. Luckily, there are people out there who can help, and that's why we recommend signing up for today's sponsor, Incogni. And you can use our link in the description or the code LegalEagle for an exclusive 60% discount. Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If those data brokers resist, Incogni will take care of that too, because Incogni fights back. Incogni also just launched a new feature called Custom Removals for subscribers to their unlimited plan that I think is really cool. It allows you to flag an unlimited number of sites where your data is exposed, and you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people search sites. These data brokers are the reason why in the U.S. you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's really shocking how easy it is to find all that information. It also might be why you're getting so many spam calls lately, or even how someone might steal your identity. Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that flood our voicemail and inboxes. I just started using Incogni, and it all seems so blissfully quiet. Who's spam texting me? Oh, that's right. No one. And Incogni will continue to conduct ongoing removals because even if the data broker removes your data once, they can collect it again. Incogni makes sure your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link on the screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. And if you keep it, you'll still get the exclusive 60% discount so long as you use our link or the code LegalEagle, all one word. After you sign up for Incogni, click here for more LegalEagle, or we will see you in court.